Hello, good morning. I'm Judge Bob Brendel. I'm sorry I'm late. I honestly I just lost track of time. But let me call your case and then we'll begin. Calling cause number 23-10-0685-CVA. In re the order for foreclosing concerning 528 School Drive, Poteet, Texas. Petitioners Deutsche Bank National Trust versus the respondents Ogden and Ogden. Your announcement for the record, please, Counselor.
Good morning, Your Honor. Maria Capo, attorney for the plaintiff.
Bring up the case. 1 second.
Mhm.
All right, the court's taking judicial notice of the entire court's file. I find that there is a notice of hearing set for today. For a motion for entry of default order. Shows certificate of service for service on Christopher Ogden and Margaret Ogden. So the Ascot Clerk's Office certifies that the article addressed to Christopher Ogden, citation with attached application for expedited order pursuant to Rule 736 on home equity loan, has been received, returned to sender, not deliverable. And also the return for Margaret Ogden, received, return to sender, unclaimed, unable to forward. And occupants been received, returned to sender, attempted, not known, unable to forward. But correct me, is this one of these deals where you don't necessarily have to prove that they got it? You just got to prove that you sent it. Is that right, Ms. Akpo?
Correct. But under the 736 rule, it just needs to be sent by email. Yes, Your Honor.
Right. So I have an application for motion of entry in accordance with Texas Rules of Civil Procedure 736-7. So one of the things I have a problem with in your motion, it says this motion, of course, was filed. Well, sworn to on the 8th day of December of 2023. So it's over a year ago that the service member's affidavit was signed off on and certificate of last known address. So I guess the problem that I have is that how do I trust this motion that was filed in December 8th of 2023 still has accurate facts? I know it doesn't have accurate facts as far as certificate of last known address or a service member's affidavit because it's over a year old.
If you allow, we are able to update that and file an updated SCRA search as well as the certificate of last known address.
But I'm not sure if these facts are, I mean, what's been going on since 2023? I'm assuming since you're not foreclosing that maybe there have been some payments made or what's going on. So it's almost like I need for you to do an amended applicant's motion for entry of order in accordance with Texas Rules of Procedure 736.7, because I can't trust anything that's in your motion that's a year and a half old.
I understand. Yeah. So since filing of this motion, the borrowers had filed bankruptcy, and that has caused the file to be on hold because of the automatic stay. And so once the bankruptcy was lifted earlier this year, we were then able to proceed with setting a hearing. But I definitely understand the court's concern with making sure the facts are updated. And if the court will allow, we will take leave and refile our motion for entry of order and set a new hearing.
Yes, please do so. I should also let you know that you have a setting on July the 8th of 2025 for dismissal for want of prosecution. So you're up against the clock as far as getting that done, please.
Yes, Your Honor. So we'll get that filed this week and proceed with setting a hearing as soon as possible.
Right. I have plenty of availability for hearings, so you should be able to have no problem getting back with me, okay?
Thank you, Your Honor. I appreciate your time.
Thank you, Akpo. You have a nice day.
You too. Bye-bye.
All right, Mr. Clark, you're here on, let me see, on SoFi Lending, right? So we are on the record in cause number 2024, DCV 2312, SoFi Lending Corp versus Valerie Waters. We are scheduled for a default hearing today. May I have announcements, please?
It's Matthew Clark, attorney for SoFi Lending Corp versus a defendant, Valerie Waters.
And do we have anyone, is there anyone here on behalf of Miss Waters? Anyone in the waiting room, Mr. Nunez?
No, ma'am.
Okay, so we're set for default. It looks like you filed your motion back on March 18th. Mr. Clark, you may proceed.
Thank you, Your Honor. This is a simple debt claim case. An unsecured loan was extended to Miss Valerie Waters. That loan was then defaulted on. At the time of default, damages were 21608. Today, we would pray for that amount. I believe it's, let me double check that that's a solid number. $21,608.50. Post charge off, there was a one-off payment of $1,000. So that's where we get the $21,608.50. So we had a motion for substitute service. They were served. As of today, there is no answer. We have our military affidavits and the SCRA showing that they're not protected under the Civil Service Relief Act. And let's see here. So we can see we have a copy of the note, its terms, the amount dispersed, its interest rates. And today, based on preponderance of the evidence, our default that was filed, we pray for the amount to be awarded in the damage to, excuse me, sorry, everybody. $21,608.50 is the amount we pray for in damages, as well as our cost of court, along with any post-judgment interest at the statutory rate that the court finds to award. Thank you.
So did we not have an answer?
No, Your Honor, this is a default.
I show an answer filed on August 16th. Is that not? Yeah, my name is Valerie Heredia Waters. I am the defendant in this case.
Back in 2023?
2024.
I don't have a copy of it, but defendant's not here today, so I'm just moving for default. But obviously, whatever the court decides.
Yeah, that request will be denied at this time. We're going to set you for a scheduling status conference in 30 days. I think, Ms. Hernandez, the answer was filed on August 16th, 2024.
Mhm.
Go back. Let me see what it's a little bit of a kind of like a form answer.
Right.
So let me see if she included her contact. Is she listed on the contacts, Myrna, for service and things like of that nature?
I'm looking that up, Judge.
Thank you. Oh yeah, she has her.
Yeah, we've served her, and she did make a payment of $1,000, but that's all we've had so far.
Okay, well, the default is denied. So we're going to set this for a status conference. Let's make sure that she is listed because I don't know if she is listed on the e-contacts. And then we'll go from there. Okay.
Absolutely, Judge. And the court will be sending out the notices to both parties, correct?
Yes, ma'am. Yes, ma'am.
And-
Oh. Yes, ma'am.
Judge, and there is an email address there for her, so I'll.
Oh, so she
Send her
failed
notice.
to appear. Okay. All
All
right.
right.
I'll note that
Superb.
she failed to appear and we do not have an entry on her behalf. Okay. Alrighty. Thank you very much. We'll see you at the scheduling conference.
Absolutely. Thank you for having me, Judge. If I may be excused till then.
You may. Have a good day.
Hey, thank you.
Any
Bye.
luck with Mr.